Ladies and gentlemen, lend me your ears and your eyes. Diva Divine Light, live from Brooklyn, New York.
No delaying for what you saying, yo. I'm silly with my 9 milli with the dilly, yo. When I be on the mic, yes, I do my duty, yo. While I'm in the club, I be while in the studio. You don't wanna violate, nigga, really and truly, yo. My main thug, nigga named Julio, he moody, yo. Like a nigga that'll slap me with the tulio. Bitch, nigga scared to death, act fruity, yo. Fuck that, nigga shorty, she a little cutie, yo. The way you shake it, nigga, you wanna get all in the booty, yo. With no delaying for what you saying, yo.
Diva Divine Light.
Really my heart to me. See what you got for me. Put more than hands with my eyes to see. Still $1 in the place to be. If you really my heart to me. See what you got for me. Put more than hands with my eyes to see. Still $1 in the place to be. If you.
You're watching Diva, the Divine Light. A fun-loving, caring, passionate person who talks about sex, celebrity, and real-life issues, and even abuse. So hit that like button and make sure you share the show.
Really my heart to me. See what you got for me. Put more than hands with my eyes to see. Still $1 in the place to be. If you really my heart to me. See what you got for me. Put more than hands with my eyes to see. Still $1 in the place to be. If you really my heart to me. See what you got for me. Put more than hands with my eyes to see. Still $1 in the place to be. If you really my heart to me. See what you got for me. Put more than hands with my eyes to see. Still $1 in the place to be. If you.
Here comes the pitch, and it comes in wide. On the combo.
Yo, 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 yo. What's up, my people? How we doing this Saturday night? Hello to my OCOV family in the building. Hello. Let's see who we got here. 100. I don't know if you're still here, but I love you, baby. What's up? Daddy's girl. What's up, mama? Take Kelly. Eva. What's up, baby? Damn, it's kind of late for you, baby. God bless you. I love you. Classy J. What's up, mama? Flores. What's up, Nisi Poo Poo? Great show tonight, mama. I'm sorry I couldn't be there the whole time, but I got a chance to jump in. And, I want that coat. So for those who missed it, if you can, go to Flawless's IG and check out her line of clothing. Jacqueline Jones, what's up, baby? Wings, what's up, my sissy poo, my twinny poo? Ruby, what's up, lady? It's late for you too, huh? In the go, what's up, my boo-boo? Hi, mama. 504, what's up, my lady? What's up, my ladies? All right, all right. Hey, Danny, what's up, mama? What's up to everyone who's in the building? I'm glad you guys are here. I noticed Levi went live. Hey, Truth. What's up, mama? I'm glad you're here, babe. I'm glad you guys are in the building. So, well, before we get started, hey, my honey bunny. What's up, lady? Well, guys, guess what? I seen that on the streets. One of these bloggers broke some news about R. Kelly. Uh-huh. Yeah, exactly, Take. We got some news about R. Kelly, y'all. We got some news about him in jail. Apparently, he's not doing too well, y'all. He's not doing too well, guys. He is not doing too well, y'all. Let me. Okay. Well, let me share my screen with y'all. Well, breaking news, according to Media Takeout, your boy, R. Kelly, is suicidal, guys. He stopped bathing and getting beat up and extorted in prison. This is all allegedly. According to, this came out today, April 30th, 2022, as you can see. R. Kelly is having a hard time behind bars. Media Takeout has confirmed. According to reports, the platinum-selling singer is getting beat up and extorted behind bars. And now, according to one of his former cellmates, Kells may be contemplating suicide. News of R. Kelly's treatment behind bars came from a prominent Chicago gang member named Jock the Block, who was currently locked up in the same cell block as R. Kelly. Media Takeout confirmed this. R. Kelly is currently locked up in MDC Brooklyn, a federal jail in New York City, filled with some of the most deadliest criminals in the world. For example, El Chapo is also currently housed there. And given R. Kelly's conviction as a child sex offender, he's having a hard time behind bars, according to Jock the Block, that claims that one inmate beat R. Kelly while the singer was asleep. And in his Instagram post, his name is Big Ol' Blocker on Instagram. If you guys get a chance, go follow him. And he posts this: when King Farmer beat his ass in his sleep, R. Kelly. Remember when the Latin King in the MCC in Chicago beat on R. Kelly while he was sleeping? That's what he was talking about there, right? Then it says the gangster claims that R. Kelly is so scared of being pressed in the bathroom that he's now refusing to take showers. I mean, he did that already. I mean, it was already natural for him to not shower all the time, right? So, now he's really stinking, So, and then he puts up this other post and it says, R. Kelly ain't take no showers. Man, I got so much to say. Okay. And he also claims that R. Kelly is now suicidal after being harassed and extorted for money more than a year ago. Take a look. And he posts this: I know he's going to hang himself on my mama. We was next door for like 14 months. So, what do you guys think about this? What do you guys think about that? Let me see what you guys are saying. All right, let's see. Okay. I kind of figured it was in the wee hours of the morning for you, Ruby. You too, Eva. Okay. Hey, love is fair. How are you, boo-boo? Tink said, oh, poor Tink Tink. Can't handle the shit he put those girls through. Suicidal. Questionable. Yeah. That was about a year ago, I guess. He was talking about it. You know, he's been locked up with R. Kelly for about 14 months. So, you know, he sees what he's been going through. I told y'all he was going to pull some bullshit. Well, I hope not. He never is, shaking my head. I hope not. I hope and pray to God. Okay? I hope and pray to God. That's so cute, Eva. I hope and pray to God that he does not off himself. We need him to face his music. According to people, he's not bathing in there either. He's scared to go into the shower, I guess, because people probably want to try to rape him. You know, he is a sex offender, convicted, officially a convicted sex offender. And in jail and prison, people really don't like sex offenders. You know, regardless of your status, man, you know, people are going to feel the way they feel. You know, Karma is a bitch and she's team victims. She's team victims. Yes, I knew it. He should feel right at home. Yeah. By this jail boyfriend's. That was my question. That sucks. He can't eat when he wants. Getting physically attacked. Can't leave when he wants. You know, what's good for the goose is good for the gander, as they say, right? You know? This is his karma. But I thought he was singing to the kids in prison, if prisoners. Yeah, he's singing to kids in prisons. He's singing to the prisoners, the guards. You know, sounds like his victims. Yeah, that's what they went through. Exactly. Hey, Just the T. What's up, mama? He's making up excuses because he doesn't like water. How is this dude on IG from federal prison? No, he's out of federal prison now. He's out of the prison now. R. Kelly should write a letter. To who? Write a letter to me, R. Kelly. I'll read it for you, brother. No, baby. There's no need for you to be sorry, mama. What's up, shorty rara? Does R. Kelly want us to feel sorry for him? Not. Exactly. Hey, Ton Bella. What's up, mama? Honey, you made it back, baby. Noni. Noni, what's up, mama? How you feeling, baby? You it's almost that time for you. How you feeling, mama? How you feeling? I want him to serve his time, not kill himself. Thank you. I want him to serve his time. I want him to serve his time. I do not want him to kill himself. I don't want nobody to kill him either. I don't want nobody to kill him. I don't want nobody to kill himself. I don't want him to kill himself. I don't want nobody to kill him. We need him to do his time. He did crimes. He must do the time. His brother Bruce said that RSK would not make it in there. He said that he was not cut out for that life. Nobody's cut for that life. Nobody is. He better not off himself before the Chicago trial. Oh, man. Yeah, like, let's pray for R. Kelly that he doesn't do that. Let's pray for him. Seriously. No, seriously. Let's pray that he does not do that. Indigo, I can't even walk. If you seen me, you would think I got off of there. Girl, I can imagine, mama. You You days away now, right? Weeks away. Weeks away. No need. Matter of fact, send me your Cash App information, okay? Text it to me, baby, okay? Okay. Man, Sylvia and her crew gonna be fasting and throwing salt all over the place. They're gonna be doing midnight private lives, 4 a.m. prayers, candle burning, salt everywhere, like you said. Oh Lord. Just the tea. If we don't sit our messy ass down somewhere. Raquel, what's up, mama? You didn't miss anything yet, except for the fact that R. Kelly has allegedly contemplated suicide, and he has not been bathing in jail. And, you know, we all know he got beat up. And they're saying that he's being extorted in jail. He's scared to take showers because he might get raped in the bathroom. And yeah, we know he got beat up by Farmer. Just lurking. Yeah. Everybody in the bushes, thank you. Do me a favor, please hit that like button on your way in. Thank you, thank you, thank you. Don't forget, guys, okay? For all my bush babies, my loves, and all the haters in the back, thank you. You know, oh, come on. Yeah, you know. Oh, I love you too, mommy. Who's getting out soon? Kedike getting out soon. Where they going? To go. Where they going? Indeed, they should make him eat his shit. I think they will. I think they will, Jackie, honestly. He's in a very, very wild prison, okay? Give it some time. It will happen. They will find out little by little. Hell on earth. Yeah, so he's not getting out before June 1st. No, definitely not. And he's not going anywhere. He's not killing himself. That's not happening. That's right, Joy. Come on home, baby. Come home. It's over. Leave the man where he stands. You don't need him. Okay? You don't need him, baby. You don't need him. Trust me when I say it. You don't need him. You don't. You really don't, baby. Hi, honey. You don't need him. I'm waiting for Sly Fox Waterworks. Ave Maria, she's going to be praying and crying and doing, like I said, 4 a.m. lives and all types of things. Queen, what's up, mama? All right. They just don't know he didn't shower when he was free. Right. They think he was always clean, fresh, fully clean. Oh, he's singing, "Is this the end?" Don't get scared now. Oh my God. You're bad, Robin. How you better at Facebook messages than texting? How'd that work, Diva? Girl, because I be back and forth. Girl, you don't understand. I get millions of messages all day, okay? And I don't go through all of them, so I skip some, I find some. It's a lot of things. So yeah, sue me, okay? I love you. Prisoners do not like sex offenders. They are considered the lowest. Yes, they are considered the lowest of the low. Yes. Hi, Missy. What's up, baby? How you doing, mama? He doesn't have supporters in prison. No, he got fake supporters. They'll pretend to support him and then rob him. Honest to God, that's what's gonna happen. I mean, I'm only being real. And you in Brooklyn? Oh Lord, you were better off in the MCC, bro. That prison, como se dice, their staff is low. I'm waiting to see the adult women that had relations with R. Kelly. Where they at? Or are they supporters on YouTube to distract the say dumb shit? Oh man. Well, guys. So, okay. Okay. So, I'm going to stop sharing this, guys. I'm good, my love. All right. So, enough of that. That was the so-called exclusive that's going on the streets right now. Okay. So, let me see if I can open this up because I'm trying to show you guys here. Let me hold on. I hope I can do it. Let me see. Share screen. I have to go to a window, right? Okay, yeah. All right, guys. So this here is Big Ol' Blocka's Instagram page. Okay. And he says here that he's fresh out of the feds. Fuck him. So he's officially out of jail. Okay. He got 8 posts, 7,424 followers, and he's only following 216 people. Okay. Embed, does that mean to copy, right? Guys, let me know. Embed means to copy, right? Oh, yeah. Okay. Here we go. All right. All right. I'm going to put his Instagram handle in the chat, guys. I don't know if that. Oh, I don't think I did it right. Oh, no. No, that's not good. Let me. Can I delete that shit? Hold on, y'all. Let me remove that. That shit looks crazy. I don't know why I did it like that, but okay. No. Where's it taking me? Okay, hold on, guys. Wait. Give me a second, y'all. All right, let me. All right. Sorry, guys. I don't know how to. I don't know how to. Oh, maybe here. Well, I don't know how to. The first one is good. I don't know. But his handle is at Big Ol' Blocker. So you could just type up Big Ol' Blocker and he'll pop up, guys. All right. He has a YouTube video here that says fresh out the feds, fuck 'em. So let's check this out. Jock the Block, 3 Summers official video. Oh, so he's in the entertainment business. Okay. Okay, so that's what that is. So now let me see. Okay, hold on. Let's see what this one says here. Okay, so he got out April 7th, guys. April 7th, he started his channel. So like he said, he's fresh out, literally. He's only been out a couple of weeks, literally. 1, 2, 3 weeks he's been out. So, yeah. This is him. Okay, y'all. So let me share that again so you guys can see who he is in his face. Let me do it again. Okay, let me fix that. Okay. All right. Let's see. All right. So this is him, guys. So he was cellmates with R. Kelly for 14 months. Or the cell next to him. Is what he said. So he says here, where's my lawyer? No 5K1. U.S.P. Lee County Max. Did my time on all 10. Came out the feds with my dignity and character. 36 months. I'm back. Okay, so he did 36 months in a federal prison. He says, don't blink. It's guns. Okay, big old block. All right, 3 summers. Okay. Okay. So that was it for that. And then this would be his lives. Oh, okay. Wait. Oh, shit. Wait. How do I? Oh, man. Oh, went too fast. Hold on. He says here, I'm really out the way because I really be living like that niggas in the way wanna be seen. Change my number. I ain't got it. All iron trust niggas. Okay. Not knocking any woman doing what she wants to her body, but to all the women with natural bodies contemplating surgery, waiting till the grown woman. Okay. Let's see what he says here. Y'all can tell the difference. Y'all can tell the difference between a motherfucker getting out of state penitentiary, that United States penitentiary, the feds, a different playing field, Rico's conspiracies, got nigga paranoid because when it go down, niggas are gonna tell. Oh. He said, I can't be around none. That's why I ain't even really been doing the music. I apologize to my fans. I gotta make it off this parole. Okay. And he shows some. Okay. Okay. Showing little clips of his video. Pictures. Okay. I was just cooking on a desk. Now I'm cooking on a stove. Free them niggas who ain't never told. Thank God for my freedom. I appreciate the smaller things in life now. Man, look, I was locked up with R. Kelly. I'm ready to tell my story. He said, for Kel's birthday, we made burritos. For Kel's birthday, we made burritos, and I got him a banana pudding made. Whole time we gave him the benefit of doubt because Chicago, his hometown. Oh, shit. Joy was outside waving at Kells every day. His was in, I guess he was in MCC, Chicago. If my bitch ain't coming like that, I don't want her. You heard what he said here? Joy was outside waving at Kells every day. His was in MCC, Chicago. If my bitch ain't coming like that, I ain't want her. Free Doc Holiday. Free King Gino. Free Supreme. Good nigga stay on the phone. Always talks with Mike Tyson. Always talks with Mike Tyson and has his movie, his good book, his books, good dude. Okay. Who was the other guy? So he's in prison with these guys. Free King Gino. He got million days worth of game. He said, wait, shit. It's hard to read them. I'm trying to read it as they're going fast too, so espérate. Got a million days worth of game from him. Learn a lot. He said all the gang leaders wanted to be like Chef Malik. He's the first gang member to get $1 million from the government. Okay. And this crazy motherfucker, Tommy the Butcher, racist as fuck, laughing my ass off, funny as hell, always drunk coffee with his crazy ass. Okay, so he was locked up with him, Tommy the Butcher. Then he says, that's just to name a few. USPA, Max, you run into everybody. Okay. All right. And that was that. Okay. So I'm going to be following him, guys. Let's follow his story. We're going to be following his story. See what he got to say about R. Kelly being locked up with him. Uh-huh. Thank you, Noonie. Guys, follow that link that Noonie put in there. That's his Instagram handle, y'all. Thank you, Noonie. So, and I have another surprise. I have a surprise, guys. I have an exclusive. Diva be finding little shit. Shit be just falling in my lap. Like, pow. Girl, look at this. Okay, so for those that are members, I got a surprise for your asses. Ladies, wait till you see. All members, I will be going live in a few days with this exclusive, okay? So please pay attention. If you are not a member of my exclusive Badass Divas Club, please join. It's only $1.99, okay? It's not a lot of money. It's $1.99 a month. You get little perks. You guys get to put little emojis, personal emojis that I put and thought you guys might like in the chat. And you guys get to see exclusive content, okay? Yes, wings, girl. You know a diva. I don't tell nobody. Shh. I know how to keep secrets, mama. I do. I really do. Yes. Girl, we are badass divas over here, okay? Oh, look it! Speaking of members, congratulations, Noonie, for being a member for 2 months now. Yay! Look, it says it. You see it, Mama? It says member for 2 months. You go, baby. Hey, Cali King. What's up, papito? Okay. I love it. And your badge says, I'm a fan. That's your 2-month badge. I'm a fan. You went from what's up, fam, to I'm a fan. Okay. Yes. What's up, Cali King? What you doing, puppy? Show Cali King some love. That's the brother from Cali. He looks like Ice-T, y'all. If you get a chance, guys, go check out his channel. He just talks about everyday life. He's really cool. I like his spirit. So you guys get a chance, say hello to him and check out his channel, okay? Show some love. Go subscribe. Even if you don't watch, just go subscribe. Just show love. It takes nothing to subscribe to someone. You're welcome, Callie. You already know, bro. I got you. I love the West Side. West Coast. I'm from the East, born and raised, but I love the West Side too. I got nothing but love for y'all out there, okay? Yeah, go say hi, of course. Yes, guys, please don't forget to like the button. Hit that like button, please. Thank you. All right. So, as I said, I got exclusive content. Thank you to all the members for remaining members. Like I said, I bring exclusive content to that section over there. And so if you guys get a chance, if you're not a member, you see, you can join. Now I know how you guys can join. I love you too, Callie. You guys, if you want to join, I just found out, thanks to Sylvia. Thank you, Sylvia, for showing me something else. You see, bitch, I give you props when props are due, okay? So I learned the other day that, you know, the $sign that you guys have in the chat there for donating to the super chat? You see the $sign on the right side? You have the smiley face on the left side, and in the right side of the chat box, you have the $sign. You hit the $sign, and it'll pop up super sticker, super chat, and then membership. So for those who want to join, you can join now and hit membership. Okay? And then whenever you guys want to use the special membership emojis, you hit the smiley face on the left side, and it should pop up all the emojis. And you can use them in the chat. Okay? That's what I got them there for. You got one that's doing ha ha ha, you know, like a laugh out loud one. One that says get it, sis. One that says keep it 100. One that says are you for real? One that says what the fuck? One that says oh really? And one that says messed up. Another one that says shit. And another one that's sipping on tea. And another one that says amen. Okay? And I also changed everybody's badges. So the old badges are not there. I put new badges for every member, for every tier as you guys go up in months. Yes. Get it, ladies, get it. Okay. Yes. I got peoples in Sacramento too, puppy. My girl out there in Sacramento, our sister Ty. Yeah. So, yes, West Coast is in the building. East Coast and West Coast. All right, so guys, we came here. Hey, honey, mama, you back, baby? So we are now going to get into reading. Oh, before we get into the reading, I'm going to drop you guys a little hint about what we're going to talk about. Okay? I'm just going to say one word, 2 words. Bruce Kelly. That's it. That's all. Bruce Kelly. That's it. That's all. That's all I'm going to say. Okay? Bruce Kelly. That's the exclusive. Bruce Kelly. Okay? Okay. We got some shit. We got some shit, ladies. Oh, yes. Gear. Yes. Girl, no. Nothing about that. It's wait till you guys see. Don't worry. Shh. No, Ruby. No. No. He is the clue. Yes, he is the clue. He is the clue. But you don't know what it's about. Dun, 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 dun. Dun, 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 dun. Wait till y'all find out. You have the patience of a gnat. Damn, Indigo. Be patient, baby. Be patient. You want to read, Ma? All right, so I'm gonna drop the link for you. Espérate. Let me get the thing I was gonna open up to Mama. Okay. Okay, hold on. Darn, it's a hack. Okay. I'm just getting a little dry throat. All right. What are we showing? Window. Okay. Share. Okay. All right. I'm sharing my window now. Okay. Okay. If I was him, I'd put a chicle gum where that tooth used to be. Best he whistles. Wait. I just lost the comment. Best he whistles real good. Okay, bet he whistles real good. Hey, Karen Johnson, what's up, lovely? Hi, Mama. The one about Bruce Kelly, Nuni, truth strong. Anytime after 5 is good for me. Wings, you can't with the Hi, my baby.
Hey.
What's up, Chula? Well,
Hey,
girl, what we're going to read today is the motion for entry of protective order governing discovery. Now, yesterday, oh, she dropped. All right, Nuni, come back, Mama. Let me explain to you guys. All right. I got you, Mama. You got it?
Yeah.
Okay. Now, what we're going to read is the motion for entry of protective order. Now, what I wanted to explain to you guys was that yesterday we had read document number 14. Okay. And it was the motion for detention, right? So after that happened, they had got a bench warrant. Then the attorneys put in for appearance. Then they did a bail report for R. Kelly, but it was sealed. And then they went and they put in a minute entry for the arraignment for his plea hearing. And then on the 18th of July in 2019, they put in another hearing, a minute entry. I'm sorry, not a hearing, but a minute entry, okay, for the arraignment for New York to bring him back to Chicago, right? Then they did the transcripts, which we read. I read already on my channel. The transcripts for the it was for his in regards to why they didn't want to give him bail and stuff. So he had a hearing for that, and it was a private hearing, and they did they had transcripts for it. They didn't put it out there. They put it in transcript form, so you had to pay for it. I got it, but before they did all that shit and sealed it and all that crazy shit, and then they reopened it because now it's opened again. You can buy it on Pacer, but when I got it free at the moment. So this document that we're reading right now is document number 43. So that's where it went from 14 to 43, because everything in between was just minute entries, a couple of sealed documents, announcements of the lawyers, and things like that. So that's what happened in between all of that. All right. Nuni, can you see the document good, Mama?
Yeah.
Okay.
Mm-hmm.
All right. So I'm going to read the first 2 pages, and then you could read the next 2 pages. We'll do it like that. Okay?
Okay.
All right. I'm going to go off screen. Okay. So document 43, which was filed July 22nd, 2019. Okay. It's only 2 pages long. So I'm going to read this first document, and Nuni's going to start off on the next document. Okay. Now, motion for entry of protective order governing discovery. Okay. Now, we all know that discovery is what? Evidence that's submitted for the trial, right? It's a list of items that are going to go in for the 3500 material, the Jenks material. Those are the things. So it says, pursuant to Federal Rule Criminal Procedure 16D and 18 U.S.C. 3771A, the United States of America by John R. LAUSCH, Jr., United States Attorney for the Northern District of Illinois, moves for the entry of a protective order, and in support thereof states as follows. The indictment in this case charges defendant Kelly with using a child to engage in sexually explicit conduct for the purpose of creating a visual depiction of that conduct in violation of Title 18 United States Code, Section 2251A. Counts 1 through 4, conspiring to obstruct justice in violation of Title 18 United States Code, Section 371. Conspiring to receive child pornography in violation of Title 18 United States Code, Section 2252A, A2, and B1, count 6. Receiving child pornography in violation of Title 18 United States Code, Section 2252A, A2, counts 7 through 8. And enticing a minor to engage in sexual activity in violation of Title 18, United States Code Section 2422B. Defendant McDavid is charged in counts 5 through 8. So let's understand that part, okay? Daryl McDavid is only being charged with counts 5 through 8. So he's only being charged with 3 counts. And 5 through 8 had to deal with the conspiracy was number 5, right? And 6 was receiving the child pornography. And 7 and 8 was enticing a minor. Oh, no, wait. I'm sorry. Let me read that again. Right. 6 was receiving. Count 6. Right. Okay. Conspiring to receive child pornography, the obstruction of justice, and conspiring to receive child pornography. Okay. Count 6. Right. And then counts 7 and 8 are also receiving child pornography. So he's got 1 count of obstruction of justice and 3 counts of receiving child pornography. Okay? So that's what Daryl McDavid is facing. Obstruction of justice and conspiring to receive child pornography. And then Defendant Brown, which is June Brown, he's only being charged with 1 count. And that 1 count is count 6, which is conspiring to receive child pornography. So those are the charges for his co-conspirators. Okay? For obstructing justice for Daryl McDavid, plus conspiring to receive child pornography, as well as receiving child pornography. And then Brown is only getting 1 count of receiving child pornography. Two, the discovery to be provided by the government in this case includes sensitive information whose unrestricted dissemination could adversely affect law enforcement interests and the privacy interests of third parties. So the government has discussed the proposed protective order with counsel for defendants who do not agree to certain terms in the proposed order. Wherefore, the government respectfully moves this court to enter the proposed protective order. So they wanted to put a protective order on the discovery in this case because it includes sensitive information. All right, so that's probably why, you guys, we don't see the discovery for this case. We saw the discovery for New York. We didn't see the discovery for this particular case. It's under seal. They protected it. It's none of us can see it. Only the lawyers and the defendant are the only ones that can see it. Okay. And this was done by the government. And this was July 22nd, 2019. Okay. Right. The next one here is document number 44. And Nuni, are you ready? Nuni, you there, mama?
Yeah, can you hear me?
Okay, yes, I hear you, baby. All right,
Okay,
you
hold
ready?
on.
Oh,
Yeah,
hold on one
somebody
second.
was kept fucking calling me.
Oh, okay, baby. No problem, no problem. Don't worry. If you gotta
I'm gonna
be
put it
cut
on Do
off for
Not
the
Disturb.
moment, it's okay.
Okay, so I'm ready.
Okay, so soap. We need some more soap. We're running low on soap now. Okay. This is document number 44, and it is the notice of motion, and this was filed on July 22nd, 2019. Okay, Nuni, ready?
Okay.
Go ahead, baby.
To Defense Counsel of Record, please take notice that on July 25th, 2019, at 9:30 a.m., I will appear before the Honorable Harry D. Leinenweber
Yeah, Lennon
in the
Weber.
in the courtroom usually occupied by him in the United States Courthouse, 219 South Dearborn Street, Chicago, Illinois, or before such other judge who may be sitting in his place and stead, and then they're present to present the motion for entry of protective order governing discovery in the above captioned case, at which time and place you may appear if you see fit. Respectfully submitted, John R. LAUSCH.
Yeah, LAUSCH.
Jr.
So now what happened is now they're going to he put in a notice stating that he put in the motion for the entry for the protective order. Now with this judge, he wants you to put in notice of motions all the time. That's his rule. We're gonna go over that on another live and talk about Judge Leinenweber and how he runs his court. All right. And then the next one here is a notification of a docket entry. All right.
Okay.
Can you see
You may
that?
read that?
Yeah.
Okay. This docket entry was made by clerk on Thursday, July 25th, 2019. Minute entry before the Honorable Harry D. Leinenweber motion hearing held, the government's motion for protective order. 43 is entered and continued to 7/31/19 at 9:45 a.m. Counsel of Defendant Brown is ordered to appear at the 7/31/19 hearing. In the meantime, the parties are to meet and confer on the terms of the protective order. The government's deadline to produce Rule 16 materials is extended to 8/1/19 regarding Defendant Kelly's transport to the EDNY because Kelly does not consent to being arraigned in the Northern District of Illinois. On his EDNY charges, the court's earlier order 29 stands as is. The defendant's presence is waived for the 7/31/19 motion hearing. Mailed notice. Attention, this notice is being sent pursuant to Rule 77D of the Federal Rules of Civil Procedure or Rule 49C of the Federal Rules of Criminal Procedure. It was criminal dockets on the First District. If a minute order or other document is enclosed, please refer to it for additional information. Okay, is this a new one? Hello? Diva?
Hey, you hear me now? I'm sorry, Mama.
Yeah.
I'm mute. All right. So now there was a hearing held for the protective order, and it was on July 31st, 2019. And then they're saying that the lawyer for Mr. Brown was ordered to appear, but they were waiving R. Kelly's presence. Thank you, Mama. Love you. Hey, Aisha. What's up, Mama? I love you, babe. Give me a second, guys. I'm sorry. I'm saying bye to my husband. Stop. Stop. Keep it up, girl. Love you too, Mama. Thank you. So, yeah. So basically, he was waiving. Now, produce Rule 16 materials. That's discovery. Rule 16 is discovery. Okay, so that's the discovery materials. To produce Rule 16 materials. Let me double check. Rule 16, if I'm not mistaken. Right. Rule 16 is discovery. Now, in Rule 16 of the federal rules, regulates discovery by the defendant of evidence in possession of the prosecution, and discovery by the prosecution of evidence. All right, wait a minute. All right, so it says that the information that's subject to disclosure is the defendant's oral statement. Upon the defendant's request, the government must disclose to the defendant the substance of any relevant oral statements made by the defendant. So, in other words, I guess it's the defendant's discovery. Relevant oral statements made by the defendant before or after arrest. Also, in response to interrogation by a person the defendant knew was a government agent, if the government intends to use the statements at trial. And defendant's written or recorded statements. So upon a defendant's request, the government must disclose must disclose to the defendant and make available for inspection, copying, or photographing all of the following. Would be any relevant written or recorded statements by the defendant. If the statement is within the government's possession, custody, or control, as well as the attorney for the government knows or through due diligence could know that the statement exists. So basically, it's the defendant's side of things. Give me 1 second, guys. Sorry, guys. I was in the restroom. Just got back. Sorry. I was changing into my pajamas, getting comfortable. The husband left. So I figured while I was using the restroom, might as well change and get comfortable. So sorry about that, y'all. So guys, so Rule 16 basically has to do with statements, tangible objects, videos and things of that nature. Places, photographs, copies, statements, police reports, things like that. All right. Let me get to the next document. Which one are we on? Okay. All right. So next is 53. Now this one's 5 pages long. All right. So this one is the protective order governing his discovery, number 53. This one was, as you can see, this is from the hearing on July 31st. Okay. It says that upon the motion of the government, pursuant to Criminal Rule 16 and 18 U.S.C. 3771 A1 and 8, is hereby ordered that all of the materials provided by the United States in preparation for or in connection with any stage of the proceedings in this case, collectively the materials, are subject to this protective order and may be used by defendants and defendants' counsels, defined as counsel of record in this case, as well as counsel of record in Kelly's cases pending in the Eastern District of New York and in Cook County, Illinois. Okay. Okay. Now that I'm going back to this here, now I can understand Bon Jean's logic as to when she's complaining to the sharing of the information between the two cases. I get it. Because as you can see here in this one paragraph, it states here that all of the materials provided by the United States in preparation for or in connection with any stage of the proceedings in this case, meaning in the Chicago case, right? Collectively, the materials, so that's the materials, the discovery, are subject to this protective order. But it can be used here, guys. It says, and may be used by defendants and defendants' counsel, defined as counsel on the record in this case, as well as counsel of record in Kelly's cases pending in the Eastern District of New York and in Cook County, Illinois, solely in connection with the defense of this case and for no other purpose, and in connection with no other proceedings without further order of this court. So Judge Leinenweber has the say-so on any of these things going on. He's the judge. He put in this order. The discovery can only be used within the cases of R. Kelly that have to deal with the Eastern District of New York and in Cook County, Illinois. solely in connection with the defense of this case and for no other purpose. Defendants and defendants' counsel shall not disclose the materials or their contents directly or indirectly to any person or entity other than persons employed to assist in the defense. Persons who are interviewed as potential witnesses, counsel for potential witnesses, and other persons to whom the court may authorize disclosure. Collectively authorized persons. So potential witnesses and their counsel may be shown copies of the materials as necessary to prepare the defense, but may not retain copies without prior permission of the court. Nuni, are you still there?
Yes, I'm here.
All right, Mama, you want to read number 3?
Number 3, certain materials disclosed or to be disclosed by the government contain particularly sensitive information, including mental health information, financial information, and information concerning the sexual abuse of one or more persons other than the defendant to whom the information is disclosed. These materials shall be plainly marked as sensitive by the government prior to disclosure. No such materials of the information contained therein may be disclosed to any persons other than the defendants, counsel for the defendants, persons employed to assist the defense, or the person to whom the sensitive information solely and directly pertains, without prior notice to the government and authorized from the court. Absent prior permission from the court, information marked as sensitive shall not be included in any public filing with the court and instead shall be submitted under seal, except in the case of the defendant who chooses to include in a public document sensitive information relating solely and directly to the defendant making the filing.
Okay. So, like it says here, only the defendant, the lawyers, the government are only entitled to see any of these documents. No one else. Go ahead, Mama.
Defendants, defendants' counsel, and authorized persons shall not copy or reproduce the materials except in order to provide copies of the materials for use in connection with the case by defendants, defendants' counsel, and authorized persons. Such copies and reproductions shall be treated in the same manner as the original materials. Defendants, defendants' counsel, and wait, did I already read that?
No,
Yeah,
you're on
that
number
number
5.
five.
You're good.
Okay, defendants, defendants' counsel, and authorized persons shall not disclose any notes or records of any kind that they make in relation to the contents of the material other than the authorized persons. And all such notes or records are to be treated in the same manner as original materials. Number 6, before providing materials to an authorized person, defense counsel must provide the authorized person with a copy of this order and require the authorized person to sign a statement acknowledging that the authorized person has received a copy and reviewed this order and has agreed to be bound by its terms and conditions, subject to sanctioning by the court for any violations of this order. Defense counsel shall maintain a copy of the signed statement of each authorized person for a period of 12 months after the conclusion of all stages of this case, and shall provide copies of the signed statement of each authorized person to the government upon request.
Go ahead.
Upon conclusion of all stages of this case, all of the materials and all of the copies made thereof shall be disposed of in one of three ways, unless otherwise ordered by the court. The materials may be 1, destroyed, 2, returned to the United States, 3, retained in defense counsel's case file. The court may require certification as the disposition of any such materials. In the event that the materials are retained by defense counsel, the restrictions of this order continue in effect as long as the materials are so maintained, and materials may not be disseminated and used in connection with any other matter without further order of the courts.
All right, I'll read these last paragraphs. To extend any material is produced by the United States to defendants or defendants' counsel by mistake, the United States shall have the right to request the return of the material and shall do so in writing within 5 days of the receipt of such a request. Defendants and or defendants' counsel shall return all such material if in hard copy, and in the case of electronic materials, shall certify in writing that all copies of the specified material have been deleted from any location in which the material was stored. The restrictions set forth in this order do not apply to documents that are or become part of the public court record, including documents that have been received in evidence at other trials, nor do the restrictions in this order limit defense counsel in the use of discovery materials in judicial proceedings in this case, except that any document filed by any party which attaches or otherwise discloses specifically identified sensitive information as described in paragraph 3 above shall be filed under seal to the extent necessary to protect such information, absent prior permission from this court. Nothing contained in this order shall preclude any party from applying to this court for further relief or for modification of any provision hereof. So they can get copies, they can make copies and do everything that they need to necessarily, but they must return materials back to the government. And if they decide not to and they want to destroy things, they have to put into notice that they're destroying things and getting rid of things, adding things, getting rid of things. And only those that are allowed to see are allowed to see. And the public can see what is made public. Everything that's under seal is under seal for a reason. And the reason is because it includes sensitive material. Now, this one is 12 pages long. And this one starts in August 1st of 2019. And this one is a motion to reconsider bail. Now comes the defendant Robert Kelly, through counsel, and respectfully request that this court reconsider its decision holding defendant without bond pending trial. In support, defendant through counsel states as follows. The Bail Reform Act is designed to permit bail pending trial. Bail pending trial has long been a part of this nation's criminal process because every defendant is presumed innocent until proven guilty. Thus, under the Bail Reform Act, courts shall hold detention hearings when the case involves any one of the enumerated serious offenses outlined in 3142F1, or cases involving allegations of particularly dangerous criminal activity, or when there are serious concerns about risk of flight or obstruction of justice are present. 3142F2 and determine whether there are conditions upon which a defendant can be released. Now, the key question at the detention hearing is whether any condition or a combination of conditions will reasonably assure the appearance of such person as regard as as required such let me read that again will reasonably assure the appearance of such person as required and the safety of any other person and the community. ID 3142F. Detention is only proper where, after this hearing, the judicial officer finds that no condition or a combination of conditions will reasonably assure the appearance of the person as required and the safety of any other person and the community. In the United States versus Byrd, the court cautioned, even after a hearing, detention can be ordered only in certain designated and limited circumstances, irrespective or whether the defendant's release may jeopardize public safety. United States versus Byrd, United States versus Chavez, Rivas. In this case, given defendant's lack of resources, willingness to submit to electronic monitoring, and lack of contact with minors, history of appearance, substantial monetary bond posted in state court, and demonstrated ability to comply with bail restrictions, conditions could easily be fashioned. Unfortunately, at the hearing here, the court never contemplated whether any condition or combination of conditions will reasonably assure the appearance of such person as required and the safety of any other person and the community. So, in these cases, they didn't, unfortunately, they didn't prove that there was any type of conditions that this guy would be always returning to the courts. There was no guarantee. So that's what they're trying to say here, that it doesn't matter what conditions he tries to say, there's no guarantee that he's going to show up. Now, the court incorrectly applied the Bail Reform Act. This court must reconsider its decision to detain because it was based on a flawed legal framework and a failure to apply the correct roadmap. The inquiry required deliberation of the factors set forth in 18 U.S.C. 3142G. Instead, this court was only focused on the nature of the charged crimes, rather than defendant's risk of flight or danger to the community. When evaluating whether there are reasonable conditions for bail, rather than considering the conduct as simply starting the process by shifting the burden of persuasion to the court, applied it as the end point. Even in a rebuttal presumption case, the overall burden remains with the government, not the defendant. So we turn now to the effect this presumption has on the court's analysis. We join the rest of the circuits which have considered this issue in concluding that the presumption shifts the burden of production, but not the burden of persuasion to the defendants. This approach is consistent with the presumption of innocence enjoyed by a criminal defendant. This court wrongly presumed the allegations themselves justified detention. They do not. They simply define the burdens. The Bail Reform Act prescribes different burdens of proof, depending on whether the question involves the efficiency of conditions to assure attendance at trial or the safety of the community. So if the former, the standard is preponderance of the evidence. If the latter, it is proof by clear and convincing evidence. 18 U.S.C. 3142 F2B. The burden of proof by clear and convincing evidence is a greater burden of proof than preponderance of the evidence. Maynard versus Nigerian. Clear and convincing evidence is evidence that places in the ultimate fact-finding and abiding conviction that the truth of the factual contentions are highly probable. Okay. The law required the government to demonstrate by clear and convincing evidence that there were no release conditions that would ensure the safety of the community or the appearance of the defendant. But the court never reached that point, nor did the government. So as reflected by the attached transcript, the court did not consider whether there were conditions which would overcome the rebuttal. Presumption of detention. It erroneously relied upon the fact that a grand jury indictment has been returned, commenting that the grand jury found probable cause of guilt. Detention transcript at page 31. Of course, a grand jury does not do that. The grand jury only finds probable cause regarding whether a crime has been committed, and it does so in a one-sided presentation, not an adversary hearing. A grand jury finding of probable cause is far from guilt. It certainly cannot substitute for clear and convincing evidence. You ready to read some, Noonie? Are you still with me, Mama?
Yeah, I'm here.
You ready to read a little bit more? Go ahead, Mama.
Okay. Here, the government argued defendant should be detained as a danger to the community and as a flight risk. The United States probation officer recommended release with conditions that would reasonably assure the safety of the community and Kelly's appearance, namely home incarceration with electronic monitoring and other conditions. Based on the court statements, it appears that the courts never considered those proposed conditions of release. CEG.G, United States versus Sabani. Court must consider and explicitly state why conditions offered by the defendant would not ensure his appearance. Having stopped after the first step of the requisite analysis, the court skipped the critical second step, determining whether there were conditions of release. A defendant cannot be detained as dangerous under 3142E, even if the presumption is not rebutted, unless a finding is made that no release conditions will reasonably assure the safety of the community. That finding cannot be based on the evidence that he has been a danger in the past, except for the extent that his past conduct suggests the likelihood of future misconduct. This is indeed the very import of the presumption of dangerousness in 3142E. To rebut this presumption, they need not necessarily show that they are not guilty of the charged crimes in the first place. They could also show the specific nature of the crimes charged, or that something about their individual circumstances suggests that what is true in general is not true in a particular case. United States versus Jessup, 757. Any evidence favorable to the defendant that comes with a category listed in 3142G can affect the operation of one or both of the presumptions, including the evidence of their marital family and employment status, ties, 2, and the role to the community, clean criminal record, and other types of evidence encompassed in 3142G3, United States versus Dominguez. The burden for the defendant is low. All that is required is some evidence that he will not flee or endanger the community if released. Dominguez at 707, the evaluation of bail requires a balance, liberty interest versus public safety. That is why there are narrowly crafted set of circumstances ever require detention. After all, pretrial detention impacts a defendant's ability to prepare a defense, restricts his contact with friends and family, subjects him to draconian conditions and rules, and bars him from making a living or supporting others. Notably, the court did not hear the specifics to any further dangerousness in the proffered evidence. A defendant cannot be detained as dangerous under 3142E, even if the presumption is not rebutted unless a finding is made that no release conditions will be reasonable assure the safety of the community. Emphasis added that finding cannot be based on evidence that he has been in danger in the past, except to the extent that his past conduct suggests the likelihood of future misconduct. Dominguez 783. Here, the best evidence that the defendant is not a current danger is the indictment itself. Let's look at the dates of the offenses. Count 1, 1998 to 1999. Count 2, 1998 to 1999. Count 3, 1998 to 1999. Count 4, 1998. Conspiracy obstruction beginning in 1997. Overt Act A, 2007. Overt Act B, 2007. Overt Act C, 2008. Overt Act D, 2013. Overt Act E, 2014. Overt Act F, 2014. Act G, 2015. Act H, 2015. Count 6, 2001 to 2007. Count 7 is 2001 to 2002. Count 8, 2007. Count 9, 1999. Count 109, 1997 to 98. Count 11, 90 in the year 96. Count 12, I think that's 1999 to the 2000. Count 13, 97 to 98. With the exception of some minor overt acts in 2015, over 4 years ago, the allegations are decades old and as stale as used gum socks. To the extent the government argued a serious risk of obstruction, they offered no facts. The concern is present or future risk. The charged.
Wait, hold on.
Conduct from the past merely triggers the application of F2B. It does not provide the proof.
All right, I'll take over. Speculating, the court commented that it would have been likely that had the prosecutors known about additional tapes at Mr. Kelly's 2008 state trial, they would have prevailed. That statement is without any basis in fact. It presupposes the tapes were admissible. It also discounts the fact that the alleged victim in that case, who admittedly the federal prosecutors now say is cooperating with them, and her parents, who are apparently not all testified before the state grand jury under oath that she was not the lady in the video. Moreover, any suggestion Mr. Kelly should be detained because of obstruction is impeached by the government's own agreement that Mr. McDavid and Mr. Brown, the co-defendant, did not have to be detained. It is also impeached by the fact that although these federal investigations were no secret and there have been pending state charges, no one has said anyone associated with Mr. Kelly or Mr. Kelly himself has tried to influence them with respect to any current investigation or charges. Further, the court must look to see what conditions can be set to mitigate this risk, and it has not even attempted to do so. Mr. Kelly no longer has the money or the entourage he once did to help him in his endeavors. Wow, so Greenberg, you're admitting that the entourage is part of an enterprise because they can't help him with his endeavors anymore? Wow, I didn't even realize he said that. Huh. Home incarceration with close monitoring by pretrial services and limited access to the internet will make it virtually impossible to attempt to contact any witnesses without being caught. The idea that Mr. Kelly has the means and wherewithal to obstruct any witness against him is frankly preposterous. Well, it's not that preposterous because they had a hidden indictment waiting to be unsealed with Mr. Richard Arline and Mr. Russell. Mr. Williams didn't even come yet. So, the court also disregarded that any accusations of sex with a minor dated back 2 decades. Notably, although the government alleges 4 videos exist, they all involve the same person and relate to the same time frame, the 1990s. There is no suggestion Mr. Kelly ever distributed. Let me read that over. There is no suggestion Mr. Kelly ever distributed child pornography. Nothing was found when a search warrant was executed at Mr. Kelly's condominium. Nothing was found at his studio when he was arrested on state charges. Nothing was found because there is nothing to find. Likewise, Mr. Kelly presents no risk of flight. He is a lifelong resident of Illinois. Mr. Kelly never missed a single court date. Bullshit. From 2002 to 2008 on his previous case. Bullshit. The court did not consider that Mr. Kelly appeared for each and every day of his trial and was present when the jury's verdict was read. The court never considered that Mr. Kelly has been aware of these federal investigations and yet did not abscond. The court never considered that Mr. Kelly boasted a substantial bond, $100,000, in connection with the now pending state court proceedings. The court never considered that Mr. Kelly does not have a passport. The court never considered that Mr. Kelly could be monitored by an electronic monitoring bracelet or GPS bracelet. In conclusion, simply put, despite the present allegations, there are conditions of release for Mr. Kelly, who has no previous convictions, that can be fashioned that eliminate nearly any risk of flight or danger to the community. He can be confined to his home with electronic monitoring, given limited access to the internet, no contact with minors, and monitored by closely pretrial services accordingly. Bail should be set. Wherefore, the defendant respectfully requests for this honorable court to order the defendant to be released on bond, during the pendency of this case, subject to whatever conditions the court deems to be necessary. Respectfully submitted, Stephen Greenberg. Well, he tried. He really tried. You know, he did the best he could, guys. He did the best he could. He was just doing his job. No. So, yeah. Okay, we just read this. Okay. All right. Now, the rest of this stuff I'll go over another day. So that was basically what happened with the discovery. It's under seal. The public cannot see any type of discovery in this case. There was an order put that the public cannot see any type of discovery. It is not for public information. Any type of materials that go in as discovery will be under seal. At least we got a chance to see the discovery for New York. At least we had that much. But for Chicago, we will not be seeing that. They put an order on any of discovery. Okay. And the discovery is to be released 45 days before trial. So, again, the defense team is allowed to see the stuff that's being put into discovery. They are allowed to go pick up hard copies, make copies of those copies if they need to help them prepare for the case. If they need to destroy something, they must put in notices to destroy things. Okay? So there are minors in this case. Luna, you here with me, Mama?
Yes, I'm here.
So that's what's going on with all of that. All right, guys. So I just wanted to read that to you guys, get that out of the way so that people can understand what was going on with the discovery, why we weren't able to see it. It was under seal. They put a protective order on any type of discovery. Okay. And also the discovery will be shown, all of it, to the defense 45 days before trial. Or 15 days, something like that. One of the two. I forgot what it was exactly. Yeah, everything's all lies. Let's see what you guys are saying in here. Okay. Hey, The Truth. Hey, Matisse. What's up, ladies? The Truth said the minors are what I've been speaking of. Of course. And nobody ever wants to talk about the minors that are in the other case. They're just stuck on New York. They don't want to move on. Move on. Where is his home right now? It's a cell. Facts. You are making it all up because you wanted him. That was the story I saw. Yeah, that was, that dumb shit that they say. That how we want R. Kelly. We're mad because we can't have him. Oh my God. That's just dumb shit they want to say just to get us upset. And
Because that's what they want.
Right. And think right away that we're going to get emotional and cry. And, oh, come on. It's all bullshit. So, it's ridiculous at this point with what they're doing. Give me 1 second, guys. Sorry about that, guys. So this case right here is going to be the other nail to R. Kelly's coffin. I don't know how he is going to fight this case. I don't see it happening. I don't see it happening. I don't. How can he defend himself against this? How? There's videos. There's all these testimonies. The parents are now testifying. They testified. They're going to testify. It's a lot. So I don't get it. I don't get why the supporters continue to say that there are no minors. There was 3 minors. 3. There was 3 minors in New York. 2 adults. In here, in Chicago, there are 5 minors from the ages of 16 to 13 years old. I don't understand why they can't see that. It says it in black and white, plain as day. It confuses the shit out of me. It's scary. Well, guys, yeah, I believe that truth. Oh, man. I know. I can see it happening. There's a lot of people going to be really hurt. I mean, it's what it is, man. It's what it is. What's up, Tears? What's up, baby? You in the bushes, my love? You know, they just keep spinning and spinning and spinning narratives. And it's like they can't get the truth from R. Kelly's side. Why? Because R. Kelly's not talking. And he's not going to talk. I wonder on the day of sentencing if he's going to say something. Or if he's going to just renege on that chance of saying something to those girls and to the people of the community. The truth. Oh, man. I just hope R. Kelly doesn't do that, okay? Let's make sure R. Kelly stays alive, all right? We need him alive. We need him to face the music for as long as he can. So it's ridiculous at this point, you know. And as the R. Kelly saga continues, guys, do me a favor. I'm about to go out. Y'all already know. Hit that like button, please. And thank you. Noonie, I love you. Thank you, Mama, for being here and for helping me out as always. God bless you, Mama. And thank you, everyone, for coming and hanging out with me on this Saturday evening. There has been a lot of things going on today. Today was a heavy Saturday. For those on the replay, please make sure you leave your comments below in the description, in the comment section of the video, please. Thank you. If you're not subscribed, please subscribe. Remember, I have exclusive content to show you guys. So if you guys are not a member, it's $1.99 a month. You can hit the $ in the portion of the chat where you get to chat, the lines of the chat. There's a $ there. You can hit that. Hit the part where it says join member. join membership, and you can join for $1.99 a month. I give exclusive content, all things private. And guys, you know, I love y'all. Thank you once again. And if you like the content, you already know you can hit your girl up at $Diva Divine Light. That's my Cash App. I got PayPal, Diva Divine Light, as well as Zelle. All right, guys, thank you for your support and your love. Diva is out. Peace.